Here in the field of Shyam Kumar Cheekooree against Lutchmee Narain Dhunnoo.
Mr. Domingue.
Yes, Lynch.
You are. It's Mr. Sabati who's here in person.
Yes, that's true.
For the appellant. Yes. Good morning to you. Good morning to you both.
Good morning, my lords.
Morning, my lords.
My lady.
Mr. Sabati, we'd like to hear you first, please, on whether you should be allowed to take your new point.
Thank you, my lord. My lords and my lady, I appear for the appellant in this matter. My learned friends, Mr. Domingue, senior counsel, and Mr. Vijay Rangan, counsel, appears for the respondent. My lords, before I start with my submissions, at the outset, I would like to make some corrections to the bundles. There are some slight errors which I would like to point out to the board. Firstly, at the electronic bundle, page 415, at paragraph 20, to delete the paragraph 17 and substitute the paragraph 19.
Sorry, 415.
Electronic bundle 415.
It's the middle of a judgment.
Middle of a judgment. Did you have 549 at the foot of the page? Yes.
It's a statement of facts and issues.
No, the statement. Well, we can go to the statement of facts and issues in hard copy. Paragraph.
Yes, I must also apologize for the confusion in the various records which were submitted to the board. I believe that finally the things were sorted out.
Well, I'm not sure they are if you're referring to a different electronic bundle number.
Anyway, you want to correct the statement of facts and issues?
Yes, it could concern the paragraph number.
Paragraph 9.
Yes, at paragraph 20.
I see. So the cross-reference in paragraph 20 to paragraph 17 above should be a cross-reference instead to what?
So it should read paragraph 19 instead of paragraph 17.
Okay.
Thank you.
Yeah.
And secondly, at page 421 of the electronic bundle, paragraph 11, this is the written case of the appellant.
Starting Sir Hamid Moulang, QC.
Yes, at the last, that is the page number,
Paragraph.
the end of paragraph 11,
Yeah.
by deleting the number 57 to 58 and substituting instead the number 59 to 60.
No, I haven't got 57 to 58 in that. Which document is this supposed to be?
It's the written case of the appellant.
Paragraph 11. Well, that's not a right reference either. This takes us to a transcript. We've got your latest version of the electronic bundle. Should we be looking at something else?
It should lead to a second amended application being filed before the tribunal. That is the Fair Rent Tribunal.
No.
No, it doesn't.
How many pages does the bundle that you're looking at have?
It should have, in all,
Not the hard copy, the electronic bundle that you're looking at, that you're giving us page references to. What's the total number of pages in that bundle?
Mali, I believe that it should be a complete record. So it should be 658 pages.
Okay, let's see if we can find a bundle which has got 658
Well, this one doesn't.
pages. Nope, not that one.
Volume 1.
All the bundles that we have
Otherwise,
have got 524 pages.
Yes.
If I may direct your lordships and your ladyship to the written case of the appellant rather than the electronic bundle. So that would be paragraph 11. In the key documents bundle, it should be page 421.
Written case for the appellant, what paragraph?
Paragraph 11.
Right. Well, there's no point correcting the bundle references because whether they're right or wrong, we have no idea.
I do apologize for that. I would rather
Well,
therefore direct your ladyship and
In
your
due
lordships to
in due course, please could you notify us what the reference should be to the electronic bundle at the end of paragraph 11?
But if you've got a bundle, an electronic bundle that has got 524 pages, it would be better if you used that because that seems to be the one that we have. We have various iterations of it, but we don't have a bundle that's got more pages than that unless you want to send us a copy. I don't know which bundle the respondent has got.
At some stage, there was some confusion concerning the various bundles.
When did you lodge this with the court, the 624-page bundle? When did you lodge it?
Well, in fact, I have the hard copies, so I'm basically...
Got hard copies?
Yes.
Here?
Yes, with me.
3 of them?
No, he's working.
I see, you've got a...
Yes, which I'm using. That is to make quicker reference rather than from the electronic bundle.
Are there any other corrections that you have to make?
Yes, one finally.
How many more corrections do you have?
And one last.
Right.
Yes. Now, this is concerning the grounds of appeal which were submitted to this Supreme Court.
Yes.
There were originally 9 grounds. 9 grounds of appeal. 9 grounds of appeal, but somehow, before the Fair Rent Tribunal, the 9 grounds became 10 grounds because the ground 5 was split into 2, ground 5 and ground 6. So that's why the Fair Rent Tribunal, in its stated case, referred to 10 grounds of appeal. So, in fact, at the end of the day, it won't make that much difference because we have to read grounds 5 and 6 together to make the ground 5, the original ground 5.
We'll bear that in mind. Thank you.
Yes, thank you, Madam.
Now, we'd like to hear you first, please, in relation to whether you should be allowed to raise your new ground of appeal.
Yes, my Lord. So I formally move to apply for permission to introduce a new point, a new ground of appeal, not taken below, in view of the exceptional circumstances of the case. And if I may allow, the new ground of appeal read as follows. It is that the stated case and the whole proceedings are irregular, unfair, and in nullity ab initio because, inter alia, firstly, the stated case dated 27th of August 2020 was signed by a differently constituted panel of the tribunal, run the panel which delivered the determination on the 2nd of August 2018. Secondly, the stated case appears to be stated, was in fact stated by a non-member of the panel and therefore not by the tribunal in breach of Section 15.2 of the Landlord and Tenant Act 1999.
Well, this is a point that should have been taken before the Supreme Court.
My Lord,
Was the point taken before the Supreme Court?
yes, it was not taken before the Supreme Court because of the very short delay between the case which was stated by the tribunal and the hearing of the Supreme Court. And
You had the statement of case. These
Yes.
points are all apparent from the statement of case. So if there anything in these points, you should have taken them before the Supreme Court.
yes, my Lord, in fact, it was not immediately apparent at that stage.
Why not?
Because it's so unprecedented and unexpected that, and I believe that it's a unique feature.
But
which
it's
has
apparent on the
occurred.
face of the statement of case, isn't it?
Yes, we had the statement of case,
Yes.
but we didn't expect that such a thing would occur in a statement of case from the tribunal. It was not discernible because
Didn't you know that the people who'd been sitting on it had retired or stood down?
no, in fact, they were not retired, but it's only that the panel changed because the panel changes basically every year. So at the end of the year, the panel would change and a new panel would be appointed.
So why is it so surprising that different people had signed the case stated if the previous ones were no longer panel members?
Well, usually the chairman of the panel is a magistrate, mostly of the intermediate court, and the tribunal sits in the intermediate court. So
It's in the what?
the tribunal, the Fair Rent Tribunal, sits in the intermediate court, in one of the courtrooms. So basically, the magistrate would be available even though that he or she no longer form parts of the panel. So they are available to sign the stated case even if they no longer form part of the panel. Now, what...
So you accept that the point should have been taken before the Supreme Court?
In fact, that would have been the ideal situation, but as I was saying, that the case was stated only 6 weeks before the hearing of the Supreme Court, and as we have stated in our statement of case, the first hearing had to be vacated because by that date the tribunal had not stated the case.
And as a result, the entire record of the proceedings before the tribunal was provided to the Supreme Court
Yes.
for purposes of the appeal.
Yes, that's correct, my lord.
So is there any prejudice to your client in the fact that the case stated may have been signed by the wrong person?
Yes, indeed. I would submit that notwithstanding that the whole record was produced before the Supreme Court, the fact that the stated case was so unfair and was not partial, the fact that the stated case was still part of the record, so it cannot be denied, it cannot be discounted that this caused prejudice to the appellant. Because
We're not concerned with an appeal against the stated case. We're concerned with an appeal concerning the Rent Tribunal's determination. And none of these points affect the points you wish to take in relation to that.
My lord, I would say that in fact it did, because not only counsel for the respondent sought support from those statements made by the tribunal, and in fact there is a previous case before the tribunal where the Supreme Court again made reference to the opinion of the Fair Rent Tribunal, similar opinion of the Fair Rent Tribunal. So therefore it's likely that the Supreme Court was influenced by the statements made in this statement.
Well, is there any indication in their judgment that that's the case?
There is, of course, there is no reference to the judgment in this case. But if we look at the judgment in the previous case, it's the case of St. Nicholas.
Well, we're not concerned with the previous case, we're concerned with this case. There's no indication in the judgment of the Supreme Court that they had any regard to the way the statement of case was expressed. Is there?
No, it's not. But I would say that still, even though there is no direct reference to those opinions or replies by the Fair Rent Tribunal, they must have indirectly, they must have been influenced by those statements.
So you say that as a result of that, we should allow the appeal and should remit the matter to start all over again?
Now, in fact, the grounds of appeal is also focused on other matters, but more importantly, what the appellant is advancing is that it is not the tribunal who stated the case. It's not by the style and language.
So what's the effect of that then? Suppose that there is a procedural defect. Why do you say that the effect of that is, or how does that affect the validity of the process before the Supreme Court, and in a way that helps your client? I mean, if the whole appellate process is invalid, then that's your appeal which is knocked out.
The effect would be, my lady, is that therefore we do not have a proper stated case for consideration by the Supreme Court.
Yes.
If the stated case is not stated by the Fair Rent Tribunal, it is written by somebody in the administrative side who is not a member of the panel. That means that there's non-compliance with Section 15.2 of the Act.
Yes, and what follows from that, and why?
And in addition to the fact that there were comments in the stated case, there were reasons advanced which were not in the original determination, and the fact that also that it was unfair. It was unfair to the appellant, the way that this was stated. And
Right, but what I'm trying to get at, because we're actually determining at this point whether you should be allowed to argue this, what is the effect of the, you say, non-compliance, assuming there was non-compliance with Section 15.2, if you're right that there had been some unfairness, how does that affect the outcome? Why does that lead to you winning your appeal?
well, the procedural defect and the irregularity, of course, would result in the whole proceedings being null and void.
The whole appeal proceedings.
The whole appeal.
So that takes you back to the existing determination being valid.
Yes, this is the point that we would be advancing, that the whole matter should be sent back to of course, the Fair Rent Tribunal is no longer in existence. It has been abrogated. So this will lead us back to the district court, which now stands for the Fair Rent Tribunal.
No, it only affects the appeal proceedings. You're right, you'd have to start the whole appeal proceeding again. How does that help you?
Well, at least we will be before a forum which will hear the case anew, and then we will have a stated case.
Why does the invalidity of the appeal process somehow affect the validity of the Fair Rent Tribunal's decision, which you're the one trying to appeal?
It affects the validity because although the Supreme Court does not state in its judgment that the views of the Fair Rent Tribunal influenced it, or they do not make any reference, the appellant would submit that these comments, these replies, and these added reasons which were advanced in the stated case influenced it in its decision, especially regarding that the Supreme Court only took up the preliminary point. It didn't go into the merits. And therefore dismissed the case at the outset.
Has any application been made to the Supreme Court for permission to take this point out of time?
No, I have to concede that this was not done. And for the reason that it was so unexpected and unprecedented that it was not immediately discernible.
Yes, but once it was discerned, once it was appreciated, why was no application made to the Supreme Court for permission to take the point out of time?
It was in fact, I have to concede that it was only when we had passed the procedure before the Supreme Court, when there was already an application for leave to the board, that this was, in a way, found out on the closer examination of the record.
Is there anything further you want to say in support of your application for permission to be allowed to take the point?
On the whole, my lord, I would say that this caused prejudice to the appellant because it was so unfair. The comments, especially the repeated statements by the tribunal that the grounds of appeal were on matters of facts and not in law. And
why is that going to influence the court? Either that's right or it's wrong. The court had to make its own determination of that.
Indeed, that of course would have been ideal. But if we look back to the case I mentioned earlier, in the case of St. Nicholas versus Arnolfi, where there the Supreme Court pointed out that the Fair Rent Tribunal observed the same statement, that the Fair Rent Tribunal observed that all the grounds of appeal were statement on facts and not in law.
Yes.
So I would submit that it cannot be ignored that the Supreme Court, in this case, may also have been influenced similarly, although they didn't state in its judgment about it. So these would be my submissions on this point.
Thank you very much.
No, don't accept it. Yeah.
Thank you, Mr. Sabate. We don't need to trouble you on this point, Mr. Domingue. We refuse permission to argue the additional proposed ground for reasons which we will provide in due course. Thank you.
As your Lordship, please. Yes.
So we move to grounds 1 and 2.
Yes, thank you, my lord. Yes, my lord. The principal issue in this case is whether the Supreme Court erred in concluding that the Appellate's grounds of appeal were not in points of law. And it is our submissions that all the grounds of appeal advanced before the board were in fact on points of law. Now, what is a point of law and what is a point of fact, my lord? I would make reference to the case of Mauritius Breweries.
Sorry, which case?
Mauritius.
The case of Mauritius Breweries.
Railways.
Where it is... Yes, it is the tab 7 of the main documents.
Sorry, what page?
At pages 514 to 526.
No, that's not going to work, I don't think, because we only have 524 pages.
Is it railways, the Mauritius Railways?
Yes.
Is that, or brewery? We've got a brewery, we've got...
Mauritius, yes, it's in fact there were a number of cases.
What is the
which were
full
taken
name of
together.
the case that you want to take us to?
So the first case which is mentioned is Mauritius Breweries Limited versus the Commission of Income Tax.
Mauritius Breweries.
And it's at page 521.
Well, we've got it at page 380 of any bundle.
That's helpful.
Interlocutory judgment, is that right? Is it the Mauritius Breweries against the Commissioner of Income Tax?
Yes, that's correct.
Yes. And this is a decision of the Supreme Court.
Yes. And I refer to, so in my record it should be
It's not.
page 521 at the bottom.
Well, we don't have those. There's no point you giving us those page references because we don't have those. So how many pages roughly into the judgment are we looking? Unhelpfully, the paragraph numbers aren't.
Sure.
There's a number at the bottom of the
Eighth-
page.
Eighth page.
There are some numbers at the bottom.
Oh, I see. So
Maybe it coincides.
Eighth page.
521, does the passage begin, the instant cases concerning the tribunal are a far cry from the facts of Hinds?
Yes, that's correct, my lord.
So,
So if you look at the bottom,
the citation from Wade, is that what you're referring to?
that's correct.
Which I think is in your
Yes.
I see.
case.
So it's at page 387 of our.
Thank you.
So you say these are the applicable principles, do you?
These are the basic principles
Right.
that are accepted by the Supreme Court in Mauritius
Okay.
as defining what is a question of law and what is a question of fact. So in that case, the judges referred to Wade and at pages 936 to 934, 944 of Wade, where the learned author goes on to give various instances of questions of law and errors of law. Firstly, what is mentioned is where there is failure of a tribunal.
Well, you don't need to read it. Which of these reasons, if any, are you relying upon?
Yes, in fact, the point 5, where there's an erroneous exercise of discretion by a tribunal, which has acted in disregard of some legal definition or principle, example, through self-misdirection or taking into account irrelevant factors.
And which of those do you say has occurred here?
Now, if we take into account the second issue before this court, and
So what's the discretion that you say being exercised?
so the issue there was whether the Fair Rent Tribunal erred in taking into account evidence of rental values from 217. Maybe I should start with the issue number 2 first, concerning the absence of documentary evidence. Now, the issue there was whether the Fair Rent
This
Tribunal
is
erred.
your ground one, is that right?
Yes,
The reference to documentary evidence.
yes. Yes.
So which of the 6 headings in Wade does this fall under?
So it is that the Fair Rent Tribunal took into account irrelevant factors in reaching its decision.
Well,
So
5 is talking about the exercise discretion. We're concerned here with a determination by the Rent Tribunal of a fair rent, which is a question of fact. So the only one applicable is whether there's no evidence, or whether a perverse conclusion has been reached. That's 4, either 2 or 4.
Well, I would submit, my lord, that the fact that the Fair Rent Tribunal referred to the absence of documentary evidence of the appellant's valuer as being the reason why it was discarding.
Well, it wasn't the reason, it was just a reason given when they decided to accept the evidence of the respondent's expert valuer. They pointed out that there was no documentary evidence to contradict it. Didn't say that's the only reason they accepted it.
Yes, so I would submit that that leads us to a point of law, because the fact that it is a reason, and which goes to the root of the decision of the Fair Rent Tribunal. So that's
Isn't that
a
just
question of law.
weighing up which evidence they want to accept? The valuation was challenged on the basis that your valuer said actually no rent is being paid there. They're just getting a percentage of the landlord just gets a percentage of the profit. And the tribunal said they didn't accept that evidence because there was nothing to suggest it wasn't. They weren't paying rent.
My lady, I would say that if we were to remove that expression in absence of documentary evidence to the contrary, then basically there is no reason which is advanced by the tribunal in justifying the retention of the respondent's valuer's evidence rather than the appellant's valuer's evidence.
Yes, but there are two rival valuations, and the Fair Rent Tribunal's job is to choose one over the other. That's what they did. So what is the error?
I would submit that if the tribunal didn't mention the absence of documentary evidence, then it would be clear that the tribunal is preferring the evidence of the respondent's valuer.
That's perfectly legitimate, isn't it?
If they didn't refer to the absence of documentary evidence, because the absence or the presence of documentary evidence was not a live issue at all. It was not referred to by the appellant's valuer.
It was pointed out. It was pointed out in
valuer.
submissions. It was pointed out in submissions that the evidence that your valuer was giving was not backed up by any documents. That's just a comment on the evidence. It was certainly pointed out in the submissions.
In fact, in submissions, there was no reference to that. There was no reference at all to absence of documentary evidence. It was not a live issue at all. It was, if I may continue, it was a point which is being taken by the tribunal on its own. On its own. And to justify its decision at the end of the day. So, in my submission, therefore, that leads to a point of law. It's not a point of fact.
Well, have a look at in our bundle, page 99, which is a summary from the record of submissions of counsel for the applicant. Which refers to the...
At the bottom of the page, it may be helpful to you, it's 141. Is that the page?
141 at the bottom.
For us, it's 99.
Yes, my lady, thank you.
So he's referring to your expert's verbal. Have you got a document?
To the submissions of the respondent's counsel.
Around line 40, just above that, he says, has the tribunal been favoured with document in support of these averments? No. That's making the point. You see that? Just above line 40.
Oh, I'm sorry, I'm just
Page 141 at the bottom, page 32 of the record.
And 33 at the time.
Yes. So that would be line, sorry, my lord.
Has the tribunal been favoured with document in support of these averments? No. So they were taking the point. Do you see that?
Yes. Now, this would, in my submission, would apply both ways. In fact, if that can be construed as referring to documentary evidence, it would be a submission, basically, in, if I may use that expression, a submission in the air.
But you were saying the point wasn't taken. It was the tribunal's point. I'm just pointing out to you that's not correct.
My lord, still I would say, with respect to your lordship, that the point only arose in the cross-examination of the appellant's valuer by the respondent's counsel when he said that, do you have documents to support it? But this, that's the only question that was asked.
Yeah.
Now, if that was a relevant, a live issue, it should have been raised by the respondent counsel with his valuer, whether his valuer had documentary evidence in support. It was a question directed to the appellant's valuer, basically without any real aim. If the counsel for the respondent...
Were you challenging what the apparent rent, if I can put it like that, of the Kestrel shop, was there a dispute about what that rent appeared to be for Kestrel, or was the dispute only whether that was actually a genuine figure or it wasn't really a comparable because that's not what they were paying, as is said at this page 141, it's not actually rented, it's a sale by levy?
Yes, that's correct, my lady. In fact, we were disputing the use of this comparable because it was not rented property.
Yes, but you weren't disputing it on the basis that the purported rental figure, which the respondents were putting forward, was in itself wrong. You were just saying, well, that may be what they say the rent is, but actually that's not the arrangement that they have. That, I understand, it was the dispute.
We are, in fact, saying that if the comparable property is not rented property, so whatever figure is advanced is neither here or there. So the appellant was contesting the use of the comparable Kestrel Digital. We were not, in fact, into the figure which was being advanced, because we were not questioning the figure which was being advanced by the respondent's valuer, because that would have led us nowhere. Whether it was 128 rupees per square foot or 200 rupees per square foot, it would have, or even 50 rupees per square foot would have led us nowhere.
Right.
Because it was not rented property in our case.
That was your case, and the tribunal decided otherwise on the evidence.
Yes.
It's a matter for them.
And the point that we are advancing before the board is that the tribunal decided on a reason which has no foundation in the evidence. Has no foundation.
But you seem to be complaining that they insisted on you producing, or your valuer producing documentary evidence, but unfairly they hadn't insisted on the respondent producing documentary evidence as to the rental, the purported rental of Kestrel Digital. But the point is that that figure was not actually in contention. What was in contention was whether that was a genuine rental figure or not.
Yes, but I would like to say that, in fact, even the appellant's valuer didn't advance any documentary evidence in support of his.
Yeah, because that wasn't in contention. It wasn't contested.
Yes, it was not in contention at all. It was not a live issue at all. It was not a live issue. And it was only being advanced in the determination by the Fair Rent Tribunal. Yes. So I would therefore submit that the fact that the tribunal took the absence of documentary evidence from the appellant's valuer is the consideration of irrelevant factor. Is consideration of irrelevant factor, and therefore the consideration of irrelevant factor leads to a point of law.
And you're relying on paragraph 5 from Wade, are you? Subparagraph 5.
Yes, as the main paragraph
Exercise of discretion.
of Wade.
Right. Okay.
Now,
Right, so that's the basis of ground one.
yes. Now, on the ground two, it is whether the Fair Rent Tribunal had in considering rental values of 2017.
Can I just clarify one thing? From what date did the new market rent apply?
My submission, my lord, would be that the rental would be at the date of the lodging of the application before Rent Tribunal in 2013.
But when they determined the rent, the market rent being 38,000 rupees, whatever, from what date did that change the rent?
So if I got your logic correctly,
Yes.
so the rental, the change in the rental, of course, applies from the determination of the tribunal.
On the 2nd of August 2018.
Yes, from that date.
So
Yes.
they were saying, on this date, this is the rent.
Yes.
And up until then, it was the agreed rent from before.
Yes.
Okay.
That is correct. But my submission,
Yes.
it is not correct to take values in 2017 merely because the application would start from the determination of the tribunal.
But they're determining it on the date of their determination, aren't they? They say, well, this is...
Yes.
So they want
Because-
to have values that are relevant to that date.
Well, if that is the case, in my submission, that would cause unfairness to the other party. And it would cause a lot of confusion.
But it only
In the
applies from the date. It
evaluation.
only applies from the date of determination. That's correct, isn't it?
Yes.
So it must be the relevant date, fair value, as at the date of determination.
In my submission, that would not be correct with respect, my lord, because when a case is lodged, it has to be based on a factual basis which is in existence at that date. In this case here, 2013.
Well, what date was your expert? What date were the values he was putting forward?
Well, it was after the lodging of the case in
Yes.
2013. So he in fact carried out his valuation exercise in 2014.
Well,
But then he relates back his values to the date of the lodging of the application. And in fact, this is what the respondent's valuer also claimed to have done in his report.
But why should you base the determination in 2018 on valuations which are already out of date if they're not, those valuations are not going to affect the actual rent payable over the interim period between the lodging of the application and the date of the determination?
It has an impact because if we look at this case, the appellant's valuer had carried out his valuation in 2014, but he relates back his values to 2013.
When you say he relates back, do you mean he discounts them?
He discounts his values to 2013.
Where do we see that?
Well, in his report, he says that he relates his values to the relevant date.
Well, as I read his report, it's page 116 of our bundle. Yes, 116, page 159 at the bottom.
Yes.
He's giving value, his date of inspection is between 2014 2016.
This is the respondent's report.
No,
Yes, this is his side's report.
Yeah, just looking at what he's done.
This is the joint report, yes.
No, this is Mr. Nunderlee, he's your valuer.
The appellant's valuer, yes.
And he's talking about a visit in March 2016. He gives his valuation based on that date, as I understand it. He then gives a table with valuations relating to a similar point in time, as I understand it, but points out the rent's been the same since 2012. Is that right? So no change.
Yes, in fact, he had carried out his exercise earlier, but then he went back on the premises just to check certain factors.
So what date is the valuation he's giving in his report?
In fact, he is giving the values of 2013. That is, he relates back...
Where does he say that?
Well, in fact, in his... I'm sorry, my lord.
Page 159 at the bottom.
Yes, this report, in fact, was filed at a later date, but there is an earlier report, which was, well, this one was following a joint visit because there was an issue about the area of the rented premises.
Well, which was the report that was before the Fair Rent Tribunal?
Well, I believe that is not in the record.
Well, this is the report. The values in this report are the values referred to in the Rent Tribunal's determination. So I assume it must be this report.
This is document D, which they refer to.
Document D is the report from the respondent's valuer. And in fact, if I may
Document E.
digress from the what I'm saying, if we look at the report of the respondent's valuer, document D, at page 157, if that's the
Yes.
correct page for your lordships.
Yes.
At the very top, where he's heading method of valuation, he states that this is based on comparison of current rents of similar recent lettings within close vicinity of the site and adjusted to reflect the characteristics of the subject property at the relevant date.
Yeah.
So
What
this
date
is
is that then?
this is to mean that he was, in fact, discounting it to the date of the lodging of the case, but in fact, he didn't actually do it, because if we look further at the subheading valuation, he says that after taking all known factors into consideration and based on a current market rent of around 185 rupees per square foot, I assess the monthly market rent of the retail unit at about 43,000 rupees as at the date of this report, which is the 16th of January 2017.
Yeah.
Now,
So that's a current rent, and that's what the tribunal had to determine. Current rent, because their determination operated from the date of the decision.
in my submission, they have to determine the market rent at the date of the lodging of the case.
Why?
Otherwise,
Where do you get that from?
From the that is the determination of the market rent, but in fact the Act does not mention at which date. The
So where
Act is silent.
do you get this rule, supposedly, that it's as at the date of the lodging, rather than as at the date of their decision, which is the date from which it actually has some effect?
In fact, there was a case which came up to the board on the issue from which date does the increase takes effect.
Yes.
That's the case of the Waqf board.
The what?
I'm sorry, if I may, which is in the bundle of authorities. The case of Lamus Sexum versus late by Remat by Waqf, it's tab 5 at pages 495 to 505.
What's the name of the case?
I think it's the one at 361 in our bundle.
361, thank you.
Some against Waqf, is that right?
Yes. Lamus Sexum.
So which paragraph do you want us to look at?
If we look at paragraph 23, my lord, that is the last page. Where it reads that the board appreciates, of course, that just as this interpretation favours the tenant, it will be seen to be unfair to the landlord, who will not be able to obtain the benefit of any increase until the tribunal has been able to determine the market rent for premises. So what the board decided in that case was that in fact the increase in rent would take effect from the date of lodging of the case and not...
Well, sorry, where do they determine that?
Decided the opposite.
Opposite.
They're saying it only takes effect from the determination. That is very unfair to landlords because the tribunal has a lot of delays, but there it is. That's what the legislation says.
Yes, so in fact that's... I'm saying that it takes effect, the increase takes effect, that is, it takes effect from the date of the determination.
Yes.
Yes, sorry, maybe
yes.
So
where does this say, but nonetheless, the value has to be as at the date the application is lodged, which would greatly increase the unfairness that they identify?
The logic in that is that if the rental values are used at the date of the determination of the tribunal, especially in Mauritius, where a case takes quite a long time,
yes,
a long time to reach a determination, the unfairness would be that one valuer may use values in a certain year, like in the present case, where the valuer used values in my submission in 2014. But the landlord used 3 valuers at different dates, and the last one was in 2017. So if we were to use the last values just before the determination, obviously it would not be comparing like with like, because the values being used by the one party's valuer would be at different dates. In my submission, that this cannot be correct in principle, because we have to use the same date for both valuers. And the date of the lodging of the case would be the more appropriate date, because it is at that date that the applicant would be saying that the market rent is well below, or at least the present rental is well below the market rent. That is why he is making an application to the tribunal for a revision of the rent.
The tribunal is fixing a rent which will have prospective effect from the date of its ruling. Is that right?
Yes.
And will be adjusted to take account of later years in accordance with the statutory formula. Correct?
That is, will be prospective, yes,
Yes.
my lord. Yes.
So in coming to the conclusion as to what is the appropriate rate, it will take account of comparables. And those comparables have to be adjusted in order to take account of what it is sought to achieve, and that is a fair rate at the date of the decision.
And unfortunately, this is not the practice that which is used. It is never the practice for the valuers to update their values at the date that they are giving evidence, or at least at the prospective date of the determination, because it is not known whether the determination would be given months after the conclusion of the hearing, or even years after the conclusion of the hearing. So that is why I say that cannot be correct, because there would be uncertainty as to when, as to which values are being taken to reach the determination. And
presumably, this tribunal knows when it looks in 2018 at a rent of a comparable that was fixed in 2015, they know, I would have thought, how to adjust that to bring it up to a 2018 value, don't they? Isn't that part of their expertise?
Unfortunately not. I mean, with respect to your leadership, this is not the casus of the tribunal, and it is not mentioned in any other determination of the tribunal. And in fact, in this determination, it is not mentioned. It is not mentioned, and we have different dates for the values of the appellant and for the respondent. Now, if the tribunal were, in effect, from what your ladyship is saying, that those values would be adjusted at the time of determination, this would be apparent from the determination, because they would be using different figures.
But any adjustment would be upwards, wouldn't it?
It's more likely than not, because it's rare that there is a depression in the market values with time. So that's why we are submitting that this would be to the advantage of a landlord to postpone the case as much as he can, so that at the latest date he will have his values being taken up by the tribunal, whereas the tenant's valuer, in this case, who had already given his report much earlier, and he was never asked to update his values.
But the reason why they preferred Kestrel Digital as a comparable was not because it was the most recent, it was because they thought the shop was the closest in characteristics to Fashion Up.
Yes, they do mention that reason, because it is in the same atrium, and it's close. So, but basically, if we look at the values, which is this issue, whether the tribunal should have taken values of 2013 rather than 2017, in my submission, in principle, the fact that in principle lead is more a question of law than a question of fact. Because if it is a question of fact, that means it would be variable. It would be variable according to the valuer's date. But the fact that the appellant states that the value should be at the date of lodging of the case is a question of principle and is a question of law.
So is there any relevant provision in the statute that deals with this?
In fact, the law is silent as to the date, as to which date the tribunal should consider the values. And I believe this is the reason why we are here today. Submissions were made by counsel for the myself, at the tribunal. Questions were asked of the respondent's valuer, and we make reference to it in the case for the appellant. He was asked which dates were his values. He answered correctly in 2017, and then it was put to him directly that was he aware that the case was lodged in 2013, and therefore did he discount his values to 2013? He said no, because he was told to obtain the values in 2017. So he didn't discount it. So how the appellant is prejudiced? Because he is using values of a different year, and the respondent value is using values of a different year. Now, it may be that values go up with time, but if we are looking at a principle, at a question of law, we cannot vary with the market how it goes. We have to be fixed with the date when the valuation has to be made. And it is our contention that The date should be at the date of the lodging of the case.
So where do you find that in the statute or any other?
It is not, but it is general principle of the lodging of a case, that is the factual basis. The cause of action must exist at the date of the lodging of a case.
Yes.
So are you saying that the tribunal should have fixed a rate from 2013 because that was the date at which the application was lodged?
Indeed, indeed.
So that if they were right in fixing this particular rate, they should have then applied it retrospectively.
Unfortunately, because of the case I've just referred to,
Yes.
where the issue was exactly there, because the landlord had claimed to apply the increase from the date of his demand, which was even prior to the lodging of the case.
But suppose sorry, go on. Yeah.
Yes, my lady.
Suppose you're right that they should have taken the 2013 value for whatever reason. Do you accept that they would then have to adjust it by inflation over the 5 years to get to a proper rate as at 2018, when the date of their determination comes?
In principle, that would have been ideal, because, of course, we have to be logical in our reasoning. But this is not the casus of the tribunal. Now, of course, as it's stated in the case of Amryz and Sexham, the problem is a question of delay. If the case is heard basically without delay and speedily, these problems would arise, because then both valuers would be having their values probably in the same year, with a difference of probably months. But in this, the practice, how it goes before the courts and the tribunal in Mauritius, is that there can be years between the lodging of the case and the determination of the tribunal.
But just be clear what your submission is. Are you saying that if it so happened that Mr. Geaton and your valuer had actually carried out their valuations in the same month, in, say, 2017, then it would have been all right for the tribunal to choose one of those? Is your submission that the problem arises here because they actually produced values at different dates?
Yes, because they had their reports at different dates, and they were not required to update their values to the date of the determination. And in this case, one valuer had given evidence at one date, and the other valuer had given his evidence at a different date. And it may well occur that several months or maybe even years may pass between the evidence of one valuer and the evidence of the other valuer. So the questions remains. I mean, is one valuer, does he have to update his values each time he comes to the court? Because the hearings were fixed from 2013 up to 2017.
Yeah, but
So at each...
what you have to deal with is whether this is a point of law or not, because that's the basis on which it was knocked out by the Supreme Court.
Yes.
So why do you say this is a point of law?
It is a point of law because it is a question of principle. A question of principle, and it's not a question of fact, which is a variable between valuers.
So are you saying that the tribunal should have determined the appropriate fair rent as at 2013?
Yes, which is
Even though it was only going to take effect from 2018?
Yes. Now,
It's completely illogical, isn't it?
I agree that there is some illogic in it, but then the solution would have been for the tribunal, or at least valuers, to not update their values, at least to cater for the inflation between those dates. But unfortunately, this is not.
Well, that would
what
be
is
worse
done.
for your client.
That would increase the
It may be.
in a rising market.
Maybe depending on the movements in the market. But again, we go back to the issue of delay. If there was no delay, then of course it would be fairer to both parties. To both parties. But
There we are.
So
Well, the tribunal took 165.28 rupees per square foot, and they applied that prospectively from the date of the decision, which was the 2nd of August 2018. It seems to have worked in favour of the tenant.
I'm sorry.
If you look at page 158 in your bundle, 115,
Yes, my
it
lady.
says Kestrel shop, 165 as from 2008.
In fact,
So he seems to be choosing a value which is actually earlier than 2013.
in fact, this what is called a plan, which was annexed to the report of the respondent's valuer. He was questioned in cross-examination about how come this plan formed part of his report. And his answer was that it was there just to show the locus of the various comparables he was stating. This is the plan of a different body.
Now, I'm not looking at the plan, I'm looking at the bottom half of that page. Just to explain this. After the word, it says valuation JCPC,
Yes.
1912-13, 2000. And then underneath that, it says comparables, JCPC, Kestrel shop, 242 square feet, 165 rupees per square foot, as from 2008.
So, in fact, all these evidence, or at least what is written there, does not form part of the record of the tribunal. It was not advanced in evidence. It came up from another value, I believe, JCPC Real Estate, who didn't give evidence before the court, before the tribunal. And the valuer for the appellant was questioned on this. But he stated that he, in fact, was referring to the plan as suggesting the locations of different comparables. So all what is written at the bottom of the page 158, in fact, does not form part of the evidence before the tribunal. It should have been admissible, but
he's commenting on your expert in that same document. So it must have been part of the evidence.
it was not brought in evidence. It may have been a precedent valuer retained by the respondent, but who didn't give evidence. The respondent, in fact, had 3 valuers, and
Okay. But
whether it is one of those valuers or not, it is difficult to say. But at least I'm sorry, my
But at
lord.
157, in his report, he's giving his comparables, including Kestrel. That was in evidence. 157.
Yes. Mr. Jeaton was the valuer who gave evidence before the
I see.
tribunal,
I see.
but not JCPC's Real Estate.
Okay, understand.
All right.
Yes.
The figures that we have at 158 suggest that the experts were, in putting forward the figures, were also explaining the date at which the valuation of the comparables had taken place.
Yes, it seems so. Yes. It seems so, but
Or the date at which that rent was fixed.
It was applicable, yes. Yes.
yes.
Yes, that's right. From would suggest it was the date from on which the rent was fixed.
Yes, that is correct, my lord. But what I would like to say is that these were not evidence before the tribunal. They were not evidence before the tribunal. This document was accepted, at least this page was accepted as being only indication of the locus of the various commercial properties.
But do you have any evidence, or was there any evidence as to at what date Kestrel Digital's rent was fixed at 165 rupees per square foot?
This comparable property was not used by the appellant's valuer, so therefore he didn't quote any.
No, but at the hearing before the tribunal, was there any discussion as to the date at which the Kestrel Digital rent had been fixed?
In cross-examination of the respondent's valuer, it was clear that his values were from 2017. That is all the values that he mentioned. He mentioned 4 comparable properties, and all the values were from 2017. And in fact, this is what he states in his report as well. If we look at page 156.
Yes, but what I'm asking is, if he had taken a value as at 2013, as you say they should, would it have made any difference? Because it seems that the rent of 165 at Kestrel Digital would have been the same rent then.
There was no evidence as to that, unfortunately, my lady.
No, well, there's no evidence other than what's at page 158, which seems to suggest that rent was actually fixed in 2008.
It is there, I agree, but this was not evidence before the tribunal. This was not evidence by the tribunal. I believe that...
Wasn't your job, if you wanted to discount the rental, to suggest that to the tribunal and give them some figures?
In fact, the values which were advanced by the appellant's valuer, it was advanced on the basis that they were correct at 2013, the date of the lodging of the application.
Right, so you didn't take into account that actually the tribunal might prefer the respondent's valuers, so it might be useful to know what the right date was for those, the right value was for
in cross-examination of the respondent's valuer, it was directly put it to him that he didn't discount his values to 2013, the date of the lodging of the application. If that issue was, that date was a controversial date, this would have been taken up by counsel for the respondent. That is not correct, or even by the tribunal. But unfortunately, the tribunal was totally silent on that issue. The tribunal didn't even adjudicate on that, in my submission, a live issue which arose during the proceedings.
Right.
So, my lord, it would be my submission that the date of the comparables properties of each valuer is a question of principle. It's a question of law.
And you say it should be the date of the application?
Yes.
Okay, I understand.
Because that's the only date which is fixed for both parties, which is known to both parties. It cannot be a variable date chosen by either of the valuer. Then would lead us to a question of fact, and then it would lead to confusion, because then either the tribunal or the valuers would have to basically do the exercise to bring their values to the same date, which is not the case of the tribunal and which was not done here. Otherwise, the tribunal would have directed the valuer themselves by proper questioning, what are your values updated to the date of the hearing, or at least updated to the evidence of each valuer, which is not the case of the tribunal. It was not done in this case.
Thank you. Well, we're grateful, Mr. Sabati. Mr. Domingo, we don't need to hear you on ground 1, but we would like to hear you on ground 2, please.
Insofar as ground 2 is concerned, I would refer, apart from what we have just identified in the evidence, which is on page 158, namely the reference to document D1, where there is a clear reference to the Kestrel shop and the extent thereof, as well as the rate which had been derived per square foot as from 2008, that is document D1 at the top of the page of page 158. We have a clear marking that the document was marked as document D1. And that will take us also to page 91 of the electronic bundle, which is at page 12 of 30 of the proceedings before the tribunal, where at the sitting of 24th of May 2018, we can see that document D was produced and filed at the top of the page.
Sorry, what page are you on? Page
91 of the electronic bundle.
I'm not sure we got.
We don't have the same page.
Which is page 20 of 30, page 12 of 30 of the proceedings before the tribunal. The date of the sitting is 24th of May 2018.
Okay, so I think that
It is the evidence of Mr. Jita on the second page. Document D is produced and filed together
page
with...
91 at the bottom, it's page 49 of our bundle.
Yeah. Ours is, it is 91. And he says document D is produced and filed.
Yes, at the top of that page, page 49.
with a footnote. To reach document D is to be found at pages 156, 157. Document D1 is to be found at page 158. And question is, together with the report, there is a plan, D and D1, and he says yes.
Now, where do we see Plan D? Is 158? Did you say?
It is. Right. It is at in my bundle. The transcript is at page 91, and it is page 12 of 30 of the proceedings before the Fair Rent Tribunal.
So that's the one working back.
So you say your page 91, our page 49 at the top, they produced and filed a plan D and D.1, and according to our index of documents, D.1 is the plan with those values. Yeah.
It was sketch plan together with the footnotes, and it was actually selected by Mr. Superbe, and we have the plan which speaks for itself.
But the point that, Mr. Domingo, the point that we have to deal with, we're not hearing this appeal on the merits as such. What the point is this a point of law or is it a point of fact? Because the Supreme Court dismissed the appeal without having heard it on the basis that it was not a statutory appeal which is limited to points of law. So what we really need you to address us on is this question of the date at which the valuation takes place, is that a question of fact or a question of law?
Well, the date of valuation is a question of law. And the date of the valuation is governed by the second schedule to the Act, which provides expressly under the Landlord and Tenant Amendment Act of 2009 that the rent payable for any business premises let on or up before 1st of July 2005 may be increased by an amount equivalent to 10% multiplied by A minus B, which is the formula which was applied concerning B being the market rent. Goes on to say that the increase shall have effect as from the first day of the month which follows the date of determination of the market rent, and at the end of every subsequent completed period of 12 months. So it is therefore tolerably clear from the second schedule that the operative date is the date of the determination and the first day of the month which follows the date of the determination of the market rent.
So which is the applicable second schedule here? Is it the one which is at your page 587 and our page 453, which seems to be a substituted second schedule?
That is the amendment, the first amendment of 2005. The first amendment of 2005 has been referred to in the case of Amryz Sexom, because that was the first amendment of the schedule which occurred in 2005. And there was a subsequent amendment, which is not included in the bundle, unfortunately, and which is the Landlord and Tenant Amendment Act of 2009, Act 21 of 2009. And this was gazetted on 24th of December 2009. And the schedule was revised, and the Act came into operation the 1st of January 2010. And it says very clearly that the determination of the market rent.
So what you're reading from the current or the relevant wording of the second schedule of the earlier Act, which was as I understand it, you're saying there was a new second schedule in 2005, which we have, but then there was another new schedule in 2009, which we don't have.
Yes, exactly.
But the second schedule in 2009 is actually the one that the tribunal was applying in this case.
Exactly. Exactly. Because we can see that the first amendment of 2005 refers to 15%. 15%, not 10%. The first one of 1999 was 10%.
But then you were reading out some other words which also don't appear in what we've got.
Yes.
But
So I'm reading from the Amendment Act of 2009, which unfortunately you don't have, but we shall be able to provide it. I have provided my learned friend with the electronic copy of it a few minutes ago before the hearing, and it says very clearly that the second schedule is repealed and replaced.
say that again.
Section 6 of the Amendment Act of 2009, Section 6, reads as follows: Second Schedule to Principal Act repealed and replaced. This is the marginal note, and this section provides that the second schedule to the Principal Act is repealed and replaced by the second schedule specified in the schedule to this Act. Section 7, marginal note, commencement. Section reads as follows: This Act shall come into operation on 1st of January 2010. And when we look at the second schedule, the new second schedule, it says very clearly that the market rent is to be determined by the tribunal.
So,
And the rent, sorry.
where does it, I mean, does the formula, apart from the 10% to 15% to 10%, is it expressed differently to the document we have at page 587?
Yes,
It is?
yes, it's different. It's different. It's no longer 15%. it has been brought down to 10% multiplied by A minus B, which is the formula which is used by the tribunal in its determination of 2018.
We'd better see this document.
Yes.
We'd be grateful if we could see the new schedule, please. Could that be sent electronically to the court urgently?
Yes. Yes.
Thank you.
Yeah.
With
This is being done immediately.
Right, but just
my-
getting back to the point, which I still think was the Supreme Court, in this case, right to knock out the appeal on the basis that it only raised questions of fact and that there was no point of law? Now, you may say, well, this is all still a question of fact, or you may say, even if it's a question of law, if it's completely unarguable, then there's nothing wrong really with the Supreme Court's decision, or what submissions are you making to uphold the decision of the Supreme Court not to hear ground 2 on the merits?
Well, I would rely on the fact that Section 15, subsection 1 of the Act is very prescriptive, and appeal only lies on a point of law. This has been canvassed in the case of Mauritius Breweries, 1996 Supreme Court Judgment 402, which is at page 64 of my bundle of authorities, where the point has been clearly established. This is again repeated by the board in 2022 in St. Nicholas case 2022 UKPC 23, and it is very clearly laid down in that decision at pages 138 and 140 of my bundle of authorities that a finding of fact may only involve an error of law if there is no evidence upon which the fact-finding tribunal, upon which it could have based a finding and which will make it unreasonable so as to be perverse. I would humbly submit that in the light of the evidence given by Mr. Digital, and given the fact that Mr. Nandalali did not seek to contradict the quantum thereof, he merely said that there is all that we have been told that this is not the rent which has been agreed upon. It is a percentage of the turnover, and he had no document to rebut what had been said by Mr. Digital, and therefore the tribunal, quite rightly, at page 463, at paragraphs 4, 5, and 6, has determined the matter on the basis of what was stated by Nandalali. And the relevant part of the determination of the tribunal at page 463 in the 6th paragraph, the last comparable is Kestrel Digital. Both surveyors gave their versions, and we have no quarrel in the absence of any documentary evidence to the contrary to accept the value given by Mr. Digital, because there is no issue about the quantum as such. The only issue was whether he was informed verbally that the tenant was not paying a rent, but only paying a contribution depending on the monthly turnover. And at paragraph 5, we read the following from the determination of the tribunal. He considered, this is Nandalali, that whatever is stated with regard to Kestrel was revealed to him orally, and he has no document to support his contention. And if we turn to the evidence before the tribunal, we will see that this is borne out in the transcript. In my bundle, it is page 134, which is page 25 of 34 of the proceedings of the 28th of June 2018. Bottom of the page, question, Kestrel again, you don't have document to support. And the answer, I don't have, no document only, it was oral. This is how we gather information or raw data on site.
But you're now addressing ground 1.
Yes.
We're not asking you about ground 1. We're only asking you about ground 2. And the question is, what is the correct date for the determination of the rent?
Well, the correct date is to be found, as I have said previously, in the amended schedule. We have uploaded the document, And it is the second schedule to the Amendment Act of 2009. And we are referring to paragraph 2A, bracket 2. Where you're searching.
The new schedule is going to be sent through to us, as I understand.
I have already sent it. It has already
court.
been uploaded.
Thank you. So your submission is that the rent has to be set prospectively from the date of the decision, in accordance with the second schedule.
Yes.
In coming to that conclusion, the tribunal takes account of comparables. The comparables in evidence before the tribunal were included those annexed, summarised in Plan D, which is a document which you have shown was produced to the tribunal. And those comparables at Plan D do in fact state the date from which the indicated rent was payable.
Exactly.
Thank you.
This is it. Exactly.
And I think you're also saying, as regards whether this was a point of law that was actually decided by the tribunal, that nobody raised this question as to the date, the relevant date, and insofar as there is any evidence as to what the date of the Kestrel rent was, it seems to have been a rent that applied for quite a long time.
Well, the only, to be fair to my learned friend on the other side, the only question which was raised by him was whether the valuation was as of 2017 or 2013. This is the only question which was asked of Mr. Jitan, but it was not suggested to him that this was the wrong date, nor was it submitted to the tribunal that the operative date should have been 2013. Had it been 2013, then you would have taken effect as from 2013. But the law is quite prescriptive. The law says very clearly in the schedule that it is only as from the month which follows the date of the determination. And this will be seen in due course in the amended Act of 2009, which I've just uploaded. And there is, as we have previously considered the matter, and the question was put to my learned friend, there is nothing in the statute which supports his contention, his submission, that the operative date should be the date of the filing of the initial application. And in that respect, it is important that I should also draw the attention of the board to the fact that there was a second amended application to fix the market rent, and this is to be found in our bundle at page 59. Proceedings of the Fair Rent Tribunal, and this was filed on the 28th of September 17, the second amended application, which was signed by Mr. Duakasino Attorney, who was attorney for the respondent, then the applicant.
On page 24.
In my bundle, it is pages 59 and 60. And it says very clearly in the paragraph 6 that the application is to fix the current open market rental value of the premises at 40,000 rupees as per valuation report of Mr. Narain Dhunnoo, Chartered Valuation Surveyor, as on 16 January 2017.
Yes.
2017, and the date of the second amended application is given as the 28th of September 2017. And there are two other points to which I wish to allude, which are very relevant in determining this issue. Second one is that there are time constraints. There are time constraints in the statute. The tribunal was under duty to determine the matter as from that particular date within 12 weeks. That will be found in the statute. And that is also, I shall refer.
Forgive me, 12 weeks from what date?
12 weeks as from the date of the hearing of the application.
Right, thank you.
Date of hearing of the application. And this is the amendment which was brought in 2005. Page 22 of my bundle, Section 7 of the Amendment Act of 2005. Section 12 of Principal Act amended. Section 12 of the Principal Act is amended by adding immediately after subsection 9 the following new subsection. Subsection 10, the tribunal shall make a determination not later than 12 weeks after the start of the hearing of an application to the tribunal under Section 11. And if we look at the date on which the matter was heard, it was 24th of May 18, at page 80 in our bundle.
It was heard on the 24th of?
24th of May 18.
May.
Yes, 24th of May 18.
Yes.
Page 80 of the bundle, in my bundle, and the determination was handed down on the 2nd of August 18, that is within 12 weeks, in compliance with Section 12 of Section 10.
Yes.
And the other additional point to which I wish to draw attention is the fact that when we look at the date of valuation of Mr. Nandalali, which has been considered previously, which is at page 159, to which your lordships have referred extensively. We may read in the middle of the page, document E, the date of valuation is given 30 July 2014, come 17th March 2016. Now, that part of his report has to be read together with the evidence which has been given by him. And the evidence in the transcript, in my humble submission, will clinch the issue. It is to be found on page 126 of the bundle, page 17 of 34, sitting of 28th of June 2018.
So page 84.
Yes. It is the middle of the page. Mr. Sibachi calls and examines Mr. Nandalali, Chartered Valuation Surveyor, and this line, and did you go on site for the purpose of your report? Yes, I inspected the property on 2 occasions as enumerated in my report. On 30/7/2014 and 17 March 2016. I inspected the property on 2 occasions, and this is the important part, and I drew up my report. The date of valuation is the latest 17th of March 16. He says so in very clear words. This is the date, operative date for him. So my learned friend is wrong from a factual, evidential point of view and from a legal point of view to insist that the operative date should be 2013. The more so as this was a renewed application in 2017. And the tribunal had a statutory time constraint, as I've said, of 12 weeks in order to make a determination. And this is a matter which is lengthily gone into in the judgment of Amryz Section, where this is repeatedly addressed, and the tribunal, this is to be found in my bundle, and your lordships will see that in the case of Amryz, at paragraph 22, because my learned friend was referring to paragraph 23 of Amryz. The relevant paragraph which should have been referred to as to the date on which the determination is to take effect is to be found at paragraph 22, where it is said that at the end of what had been a vigorous debate, the minister indicated that he had changed his mind. He said this: as for the amendment that I'm going to propose, previously we had from the date of the request for increase. This is what was submitted by my learned friend Mulan in that case. And The Minister added, we believe it is very fair that we replace it by, quote, from the date of the agreement on or determination of the market rent. So that is very clear from paragraph 22. And the concluding part, an amended version of the second schedule, which included these words, in paragraph 3 was brought forward as promised, and it was approved when the bill was considered at the committee stage. And that is the version of it that passed into law when the bill was enacted. And in paragraph 23, the board did refer to the time constraint of 12 weeks, middle of paragraph 23. The problem is one of delay. Among the amendments that the 2005 Act made to the 1999 Act was the additional section 12 to section 12 of a new subsection 10, which I have just read, which provided the tribunal shall make a determination not later than 12 weeks after the start of the hearing or application to it under section 11. So, and there are observations which are made as to the time constraints and the need for the tribunal to respond as quickly as it may to requests for the determination of a fair rent for all manner of premises. So these are the reasons which militate in favor of the submission that it could only be prospective and certainly not retrospective, as my friend is contending. This is not what is provided for in the statute, and this is not what we read in the case of Lamus.
So just going back to what the Supreme Court actually decided on this, which is at page 229 of our bundles, it might be 312 of your bundle. What they seem to have decided is, as regards ground 7, which is that it should have been the date of July 2013, this they don't seem to reject on the basis that it's a question of fact. Rather, they reject it on the basis that it has no merit because of the amended application that was filed on the 28th of September 2017. Is that a fair reading of what the Supreme Court has done in this case?
Yes, that is so.
Right. And is that generally accepted, that they can reject an appeal on the basis that it has no merit, even if it does raise a point of law within the meaning of the statute?
Well, the Supreme Court at page 451, that is the fourth page of the judgment, at paragraph 2, concluded as follows. Furthermore, we wish to add that even though I set out in ground 4.2 that there was...
No, I don't know where you're reading from. What document are you reading from?
On the judgment of the Supreme Court.
Page 227,
Yeah.
second
Yeah,
paragraph.
And it starts at page 4. The fact that the tribunal took into consideration the absence of documentary evidence to the contrary does not, in our view, amount to taking irrelevant matter into consideration. It was a passing remark which showed that tribunals considered the evidence adduced by both surveyors and was more inclined to accept the evidence of Gitan since there is no other evidence, such as documentary evidence, to contradict Mr. Gitan, which is a fair summary of what has transpired before the tribunal, in my humble submission. And they went further. Furthermore, we wish to add that even though I set out in ground 4.2 that there was evidence from the appellant and his valuer...
Well, this is all relating to ground 1. We're trying to focus on ground 2, this date point. Right, the date of the valuation of the rent, right? And I'm just trying to work out, looking at the final page of the judgment, what the Supreme Court actually decided as regards ground 7.
This is to be found at page 5. At on page 6 of the judgment. In respect of ground 7, it is the contention of the appellant that the question of law to be
Yes,
determined.
we're all looking at that. What I'm asking is, what is your submission as to what the Supreme Court did in relation to ground 7? How would you legally characterise the reason why it rejected ground 7?
Well, this is a question of law to be determined by this court, is whether the tribunal should have determined the market value as of 2013 or 2017. Well, this is clearly a question of law, in my humble submission.
Right, so are you saying that this was actually a point of law, but they dismissed it as having no merit? Is that what you're saying?
But they go on to say, in the last but one paragraph, now the record of proceedings for the tribunal shows that, in fact, the respondent and the then applicant filed an amended application, as I said, on 28 September 17 before the tribunal, and the matter was heard thereafter. In the circumstances, we fail to see any merit in the submissions of counsel that the tribunal should have considered 2013 to determine the market value. They could have gone further than that. They could have engaged with the relevant provisions of the Act, but the fact is that they took into account the amended application of 28 September 2017.
Yeah.
It might be said against you, Mr. Dominguez, that in fact this reasoning of the Supreme Court lends support to the view that the question should be one of the market rental value at the date of the application. They took the 2017 date as the date of the application, not 2013.
Well, the date of the application was 2017.
I understand that, but it suggests that, but for the fact of the new application,
Yes.
that Mr. Sibati might be right.
Well, the first application of 2013 had been overtaken by the fresh application, amended one of 2017, which was signed by the applicant solicitor,
I
on which
understand
there was a plea which was filed, on which the case was heard, on which the matter was tried, on which evidence was given. So everyone was focused on 2016, 2017. And we have already pointed out that the evidence of Mr. Nandal Ali was in relation to 2016.
Yes. I think you would say, Mr. Domingo, would you not, that even if there hadn't been an amended application in 2017, that nevertheless, when you look at the statute and Schedule 2 in its amended form, it makes it clear that the assessment has to take place by determining the market rental at the date of the decision.
And the date of the determination, yes, that is my submission. This is a matter of law. Under the Landlord and Tenant Amendment Act of 2009.
Very good. Thank you. Thank you, Mr. Dominguez.
Thank you.
Mr. Sibati, we can hear you in relation to ground 2 in reply.
Yeah, if I heard my learned friend correctly, so he seems to be agreeing that it's an issue of law. It's only that it's an issue of law, that the date of the application of the rental values is a question of law.
Yes,
although we do not agree
that may
on
be the case, but then what the Supreme Court did was that they considered it and dismissed it on the merits.
Yes, exactly. I think your ladyship is very right.
Yes.
They didn't go into the issue whether it was a question of law or not.
No.
They went aside it, and they looked at it on the question of merits, and they dismissed it on the merits.
So you say they're wrong as a matter of law.
So yes,
It should have been the 2013 date.
yes.
Right.
Now, my learned friend seems to agree that the date of the valuation is a question of law. It's only that my friend is advancing that the date, the effective date, should be at the date of the determination, whereas in my contention, it should be the date of the application, because that is the only certain date which is a matter of principle and applies to all application.
Well, there are two submissions against you as far as that. There are two submissions against you so far as that is concerned. The first is that the effect of Schedule 2 in its amended form is that the assessment should be at the market rental value at the date of the date of the decision of the tribunal, and the other is that in any event there was an amended application in 2017.
Well, on the first point, my lord, the decision of Lamis and Sexum was on at what date the increase would take effect. It's not on the date of the values. And the board concluded that the date of the application of the increase would be from the date of the determination.
The board determined that?
In the case of Lamis.
In Amryz?
In Amryz.
Yes.
Which is a different question from what we are concerned here with. So, in my submission, the decision in Lamis section cannot be used as indicative of at what date the rental value should be taken. Because even if we take the rental values at the date of the application, the increase can still take effect from the date of the determination. And I believe that what the board, in effect, was suggesting, because if we look at the contention of the landlord in the case of Lamis, they were seeking to apply the increase from the time of the demand, which is basically the date of the lodging of the case. It would be far from that. Whereas the decision of the board in Lamis system would in fact be going to the date of the determination of the tribunal, which is, of course, prospective. Now, my learned friend also is suggesting that my position is that the increase is retrospective. No, I'm not saying that. I'm saying the increase is prospective, but the value should be taken from the date of the application, not from the date of the determination. And I have also submitted that if we take the date of the application, it is the only certain date, and it is only a date which will apply to all cases. Whereas, if we take the date from the date of the determination, then the valuers would have to do an exercise of updating their values to take into account inflation, and also whether there have been changes in the market, which is not reflected in the evidence.
Well, so you're creating a whole bunch of problems that you don't have if you actually take the valuation as at the date of the determination.
Indeed.
That you have to
yes,
find some index by which to increase the 2013 value, and then you have to look at whether some other big shop was opened up nearby that took away a lot of business or that sort of thing. But if you choose the date of the determination, you don't have those problems.
But then the valuers would have to do a constant exercise of updating their values each time they appear before the tribunal. And like in this case, there have been several hearings, and it is very much possible that one valuer would give his evidence on one date, and the other valuer would give his evidence in another date. So, therefore, would the first valuer be called back again to update his values at the date of the second valuer? And this is what happened in this case. The valuer for the respondent gave his evidence, started his evidence on one date, completed it on another date, and the valuer for the respondent gave his evidence on another date. So we will have 3 dates of where the valuer would give evidence, and if the date of the determination is the relevant date, so therefore it could be a never-ending exercise of updating to give the correct value before the determination is given. Now, my learned friend also suggested that this was not raised in submission. In fact, it was. If we look at page 140 of the end, it's the end of my submission, this is what I stated below.
Now, you're going to have to help us as to where we find this.
Yes, it should be the correct page, 140, because the
140.
document D1,
114.
140,
144.
140,
14.
140,
140. Okay.
yes.
But it won't be that in
What
ours.
are we looking at?
This is a transcript of submissions.
Yes.
So it's page 98.
I do apologize for the confusion in the page numbers.
Right, so we're at page 140 in your bundle and page 98 in ours. And which line?
Yes, so it's basically from line 13, where I read. There is also the issue of, because we know that valuation may go up with time, this case was lodged in 2013, and Mr. Jeaton's valuation is based on his visits. Well, in fact, it should be 2017 rather than 2014. Although he also goes, I think it's probably the appellant's valuer, Mr. Nandalali, who I'm referring to, and he goes in 2016 and 2018. It would be submitted that we have to look at the valuation as from a date of application, that is 2013. If a valuer comes up in 2017, he has to extrapolate or discount his values to the time when the application was entered, because it is logical that the values may not be the same in 2018 when compared to 2013. If we accept the latest values, that would mean if a landlord enters his application, it would be in his interest to drag on the case and then to get another value at the very last moment, and therefore take advantage of the increases in the rental values and present them to the court, as if we cannot go into a situation where we are. Rental values are always moving with time, and therefore because of this benefits the landlord and the tenant. The values will have to be fixed at the time of entry of the application. So it was raised in submission. Counsel for the respondent did not give any submission on that issue, and the tribunal did not adjudicate on that issue at all. So failure to adjudicate on a live issue, which was raised not only in cross-examination but also in submission, is a question of law. Now, as to the consideration of Ground 7 by the Supreme Court. Now, as my lady has earlier suggested, it was the Supreme Court considering the ground on its merits, not whether it was a question of law or not. Now, on the second part, where my lord is saying that because the Supreme Court was saying that an amended application was filed in 17, so therefore, and the tribunal heard the matter thereafter, so they found that there was no merit in the in Ground 7. Now, what the tribunal is in fact suggesting is that because the amended application was filed in 2017, and therefore the values may be, because it's not clear whether they are suggesting that the values should be taken at 28 September 2017. They are merely saying that we don't see any merit in the submissions. So, in fact, both paragraphs are considering the merits of the case. It is not that the first paragraph is considering the merits and the second part is dealing with the issue whether it's a question of law or not. And if I may restate again, the date of the valuation is a question of law, and my learned friend seems to agree that it is a question of law because he is grounding his point on the second schedule to the Landlord and Tenant Act. But this is where we disagree. He's suggesting that the date should be at the determination, whereas in the appellant's contention, it is at the date of the lodging of the case. So it is a question of principle, it's a question of law. It cannot be a question of fact between the date of the application and the date of determination.
But there's no statutory provision that you rely upon?
Yes, unfortunately the statute is silent as the date. So just to finish on that point, a third person cannot come up with a different date between these two dates. Then it would be a question of fact, but it cannot be. It has to be either the two dates, which is therefore a question of law. So unless I can assist your Lordship any further.
Thank you, Mr. Sabati. Mr. Sabati, Mr. Dominguez, we're grateful to you both for your submissions and to those instructing you. The board will take time to consider its judgment. The court is now adjourned.